All right, I think we should get started. Hello, everyone. My name is Scott Starbird. I am a Chief Public Affairs Officer at Databricks. And I'm very happy to be here to talk with you this afternoon about regulation. I would like to make a special introduction before I dive into the presentation. We have Alan Davidson over here with us. And Alan is starting at Databricks this week. In fact, this is his third day as Head of Government Affairs. Alan was Undersecretary of Commerce in the prior administration, heading the NTIA, the National Telecoms and Info Administration, and they had a leadership role in advising the White House on AI issues and other technology policy issues, including, if you remember, there was an analysis and a report done on frontier models that were open source. That was Alan's group, and so we're going to have him help me with questions at the end. So a reason to stick around, and also a reason I'm going to go a little bit fast through the presentation so we have as much time as possible. We are talking a little bit about forward-looking statements, no guarantees. Please get your own advisor for any important decisions. I've been asked to remind everyone to fill out the survey, so consider yourself reminded. Let's just dive right in. I always like to begin these with a reminder that there are a range of laws on the books that already deal with AI. They just need to be repurposed a little bit, but they don't need to be re-legislated. And things like privacy laws and the anti-discrimination laws in particular, the anti-deceptive practices laws, and governments everywhere are being a little bit more aggressive in figuring out how to apply these to AI, particularly in the current environment where the focus on new AI regulation is kind of dying down. But in a way, just to reassure, if there's no further AI regulation, we do have some protective laws on the books. Just a quick snapshot on where we are. The EU AI Act is still kind of the guiding light. It remains the only comprehensive, globally impactful set of AI regulations in place today. And in the U.S., at the federal level, there still is relative inactivity at the federal level, and that vacuum is continuing to be picked up by lots of activity at the state level. And then in the rest of the world, there was a lot of interest in regulation a while ago. There's some modest efforts that have moved forward, but for the most part, leaders everywhere are kind of backing off a little bit and refocusing on making sure that their jurisdictions, their countries remain competitive and that they're not falling behind in terms of innovation. Before we start talking about what's actually on the books and in place, an important caveat. There's a lot of talk in a variety of places about slowing down the rollout of some of these laws. I'm sure you've read in the press in the last few weeks about this effort by the Republicans to insert into the reconciliation bill this 10-year moratorium on enforcement of all AI regulation by the states. Very controversial. I'm going to ask Alan about this at the end of the presentation here. He might have some, ear to the ground information that could help us understand that. In the EU, similarly, there's a recent effort or set of conversations going on about possibly delaying the enforcement dates of the EU AI Act. Poland recently introduced, just in the last week or two, introduced a motion at the ministerial level to have the act delayed, with a concern about protecting innovation in the EU. And then you've got leaders in states, both sides of the aisle, and leaders in other countries that are increasingly refocusing on making sure that innovation isn't held up. And so a little bit of a defocus on regulation. So the EU AI Act, let's dive right into the act. It is kind of, it sets precedent everywhere. There's two major milestones coming up just in a few weeks. August 2nd, the obligations related to general purpose AI models go into effect. And then a year after that, the meat of the act, which deals with the deployment based on risk case, those obligations go into effect. Many of you have probably looked at the EU AI Act. It is the deployment risk-based part of it where the meat of the obligations are. looks at 4 different risk categories. The high risk, or sorry, let's start with the unacceptable risk category. Very explicitly delineated in the Act, deals with things that I think most of us would agree AI shouldn't be allowed to do. Things like modifying human behavior, and those are outright prohibited. The next category, where the focus of the Act is on the high-risk category. And basically, this is AI systems that impact fundamental rights, access to public services, healthcare, et cetera. And there are extensive requirements there. We're going to touch on that in a bit. The next category is limited risk, anything that doesn't meet the high-risk threshold, but that does interact with humans. And there, the only real obligation is that it needs to make sure that the human is aware that they are dealing with AI. And then the last bucket, called minimal risk, is basically everything else. And there are no formal obligations. The Act does encourage the adoption of an AI code of conduct by any player dealing with AI, but no formal obligation. High risk, it's defined fairly exhaustively in 2 different annexes in the Act. Annex 1 deals with pre-existing laws that already address relatively risky areas, where conformity assessments, a major requirement under the Act, are already required. And so if AI is part of one of these sets of products, then it automatically is considered high risk. And then Annex 3 is more AI focused, a little bit broader brushed, but 8 general categories. And these are the categories that I mentioned a minute ago: healthcare access, financial services, et cetera. There's a limited set of exceptions. The major one has to do with areas where there's no significant risk to fundamental rights, but the intent of the system is for what they call a narrow procedural task. Busy slide, just in a nutshell. Pre-release, the major obligations apply they relate to testing, identifying risk, taking mitigation steps, putting in place a risk management system, a quality management system, and then the conformity assessment, which is basically the written document that goes through what steps you've taken to conform to the Act. And then if fundamental rights are impacted and personal information is present, then there are appropriate impact assessments relating to those 2 areas as well. And you have to register the system in the EU database. And then post-launch, there are ongoing monitoring requirements. You need to do incident reporting. You need to flow down documentation to downstream players, et cetera. So there are 2 buckets of obligations in the Act. One relates to the deployment based on risk, which is what we just went through. The other bucket has to do with general purpose models. This is the area that's a little bit more controversial and the area where there's more, I think, a little bit more concern that there may be impact on innovation. Plus the definitions of what constitutes a systemic risk model, for example, are somewhat controversial. But I think it's best to divide the models into these 3 categories and look from the least restrictive to the most restrictive. On the left, you have open source models where there are only 2 obligations. One is that the developer, called a provider under the Act, does have to follow the copyright laws of the EU when it comes to training. And then in addition, you have to post a summary of the training data. So for closed models, in addition to those requirements, there's technical documentation required, other documentation and support required for downstream integrators, and you have to appoint an EU representative, much like with the high yield. I used to be a banker, so I keep calling high risk high yield, kind of the same thing. But where you have to appoint an EU representative, just as you do if you're a high yield deployer, or high risk deployer. And then additionally, there are copyright policy requirements that come into play regarding outputs. And you need to keep all of that updated. So models with systemic risk are models that are frontier models, the primary definition of which is a model where the compute involved in training was greater than 10 to the 25th floating point operations. That threshold is part of the controversy about the systemic risk regulations. And for those models, there is more extensive testing required, including adversarial testing, also known as red teaming. Importantly, there is not a requirement in the Act that the red teaming be done by a third party. You can do it internally, although the guidance that the Commission is expected to publish is expected to include a recommendation that the red teaming be external. And then, as with high-risk deployment systems, there is ongoing monitoring and alerts required, incident reporting, et cetera. Switching to the US, the Trump administration, the stance basically is no regulation. The actions they've taken are to start the process of developing an action plan, AI action plan, which is expected to focus on how to maintain AI leadership by the US. They have done everything they can to repeal anything that was done under the Biden administration relating to AI, where they could repeal anything. A lot of it was studies that were done, like the study that Alan's group did. So they can't really repeal that necessarily. But they are looking to root out anything where bias in AI there was an attempt to address that. Much of that has to do with use of AI within the government. And they reduce staff, particularly with respect to the AI Safety Institute, which they, by the way, have renamed because they want to take it away from the prior association with the UK Safety Institute and the globalization issue. And then separately, they're trying to promote third-party investment in data center build-outs. I think J.D. Vance probably expressed the Trump policy most clearly at the Paris AI Summit back in February. His 4 major points were maintain U.S. AI leadership, limit regulation to promote innovation, keep AI free from ideological bias, and be pro-jobs, enunciating a belief that AI can be used actually to protect, as a potent tool for job creation, to quote him. In terms of what's going on in Congress, all eyes have recently been on this 10-year ban on state AI enforcement. Separately, there is a Republican privacy task force in the House that's been set up to look at a national privacy bill, and they set out a request for information, which we've contributed to. And in it, they included questions about AI, whether there should be AI provisions, and with a focus on whether they should be preemptive. It's clear that the Republicans in Congress would love to see something that would be preemptive. And I think most industry players would like to see that as well. It's a question of what is it? Is it just an outright moratorium, which probably, I would argue, wouldn't be the right idea, but or some kind of a balanced, reasonable set of regulations. And I think they're going to pursue both paths, by the way. There are some bills that can get by, like the recent Take It Down Act, which addresses non-consensual intimate images produced by AI. That was passed with near unanimity on both sides of the aisle, and Trump signed it a couple of weeks ago. Interestingly, it explicitly did not preempt state laws because both sides, Republicans and Democrats, wanted to make sure that states were free to go further if they wanted to. So switching to the states, there is a growing patchwork of significant laws. This just colors in the states that either have significant laws on the books or where there are significant laws moving along pretty rapidly. There are other narrow laws in many of the other states as well. So there is a meaningful patchwork. Connecticut, the bill did just fail to meet the deadline, so I should uncolor it from brown. But even without Connecticut, these states still represent almost 40% of the population. So a significant hunk of the market. And if you're an AI developer or deployer, you need to navigate this patchwork if you're national in scope. Just to give a quick idea of where these laws, what kinds of things they address. In the far left, you can see that most of the laws that have been passed or are pending are addressing deepfakes, like the Take It Down Act. Just focusing on the dark green bar at the left of the clusters, those are the number of states that have actually enacted laws as of the date of this slide, which is a few weeks ago. You can see 17 states have deepfake laws on the books. And then switching to the far right, comprehensive AI law, the one state there is Colorado. Another way to look at the different kinds of laws that states are passing is to categorize it based on how AI is either used, affecting deployers, or built. Affecting the developers and the underlying technology. I make this distinction because in the discussion about whether regulation will impede innovation, it's important because it's very clear that regulation that addresses the right side of the slide here, that how AI is built, is more likely to impact innovation. We'll come back to this in a minute. And then just to make an argument for the need for preemption, this looks at 4 different states all pursuing frontier model bills, and with very different approaches. This is the new bill for this year from California. It was scaled down from last year, the one that did not pass last year. It focuses on whistleblowers. It has a very unique and complex definition of frontier model. In Illinois, the Illinois Act calls for risk assessments every 90 days and publishing an annual third-party audit. The Rhode Island bill calls for strict liability. And it has a private right of action. The New York bill, I think this is still in the New York bill. The New York bill is moving forward as of the last day or two. But at least at one point, it talked about this nebulous concept of a safety incident, reporting any safety incident that had a demonstrable evidence of an increased risk of critical harm, which could be interpreted in very different ways. Now, if all 4 of these bills were to pass exactly as worded at the time this was put together, that would be a huge headache for developers of frontier models in terms of navigating the regulation patchwork. We looked at the Colorado Act because it is in place. It's the only comprehensive law. I'm not going to go into detail here, other than to say that it did go beyond the EU AI Act a little bit in a few areas. The amendments were meant to scale it back and to delay effectiveness. They didn't get by this session. There is talk of a special session, perhaps relating to the reconciliation bill, depending on its impact on Medicaid in Colorado. If that happens, the betting is that they'll reconsider this and it may get at least the extension beyond next February 1st, which is when it goes into effect, might occur. So there's, I think, a growing sense that the Colorado Act will be scaled back, if not delayed. And then in California, California's important because there's so much activity going on. There's a number of narrow bills on the books. The training data disclosure bill is going into effect in January. And then just in this session, there were about 30 bills introduced, most of which are still alive and moving along, including the frontier model whistleblower law that I mentioned. There is a sense, though, that some states are backing off. In California, for example, the current frontier model bill is scaled back from the one that failed last year. In Virginia, the bill passed both houses, but the Republican governor vetoed it. I mentioned that he's Republican because the 2 houses are Democrat in Virginia. It was open whether Youngkin would veto it or not, but he did end up vetoing it. In Texas, the comprehensive bill was scaled back pretty significantly. It's on Abbott's desk. Don't know for sure if he's going to sign. Alan may have a view on that. I don't know. But and then the Connecticut bill was scaled back a lot, yet still didn't proceed. The counterpoint, though, is the Colorado Act, where amendments were attempted but didn't make it through. And then outside the U.S. and the EU, a similar pattern is going on. In the UK, they're very explicitly avoiding regulation to focus on innovation. In Japan, there was a light law passed recently. It focuses on innovation. It has some guidance in terms of safety, but no real penalties whatsoever. In Korea, there's an act that did go a little bit beyond the EUA Act in a few areas. There's now talk, interestingly, about delaying the effectiveness of that law in Korea, but it mostly conforms. And China, the regulations are pretty narrow, and importantly, they exempt the state, which is where most AI is used, at least on a big scale. So turning to this conflict between regulation and innovation, is there really a conflict? It's interesting to look at the views of the Trump AI team, although Elon Musk, I guess, is not part of the team anymore. I'm not sure, but back in 2018, he said that AI is more dangerous, far more dangerous than nukes, and it's insane not to regulate it. President Trump, just a little over a year ago, in an interview, said that AI is maybe the most dangerous thing out there and that something has to be done about it. But the administration has really coalesced around this non-regulation stance, pro-innovation. And I mentioned the points that J.D. Vance made at the Paris Summit. Here's a quote from him talking about how regulation could kill the industry. And even the EU is getting in on the act in terms of this mantra. This is a quote from the president of the EC, where she pointed out first that instead of 27 different national regulations, at least the EU just had one uniform regulation, which is a little bit of a touche compared to you guys in the US. But then went on to point out that they will focus on cutting the red tape. The 3 states where the major AI bills died recently at the governor level, 2 Democrats, 1 Republican. The point here is that all 3 of the governors cited a concern about making sure that innovation wasn't impeded in their states. So this is a big issue that political leaders everywhere are concerned about. They want to make sure that innovation isn't impeded. This is a repeat of the slide I showed earlier. Remember the point being that regulation that attempts how AI is built is more likely to slow innovation. And in thinking about possible state preemption, I think it's important to think about that because like the frontier model bills that I went through a minute ago, they focus on how AI is built. And if you're really interested in spurring innovation, you probably ought to be focused on preemption in that area. Maybe it's just that narrow area. A lot of trade-offs we could talk about between innovation and regulation. The point at the top is the one that, to me, is that resonates, and that is that regulation has the greatest impact on startups. And they are a major source of innovation. I've been involved with a couple of startups, and I've seen the difference between startups and big companies, and regulation can be a big issue. And regulation, some level of regulation may actually increase trust in AI and adoption, and in the long run, maybe help innovation, especially if it builds the market quicker and in a bigger way. Moving on, these are just some examples of industries where it's pretty clear that regulation has slowed adoption and in many cases innovation. But focusing on AI, the Meta example is the clearest example where they've held Llama 4 back from the EU because of the EU AI Act. Remember the systemic risk model obligations. They don't exempt open source, and they're pretty burdensome, and you can't really follow an open source model and meet those obligations. And so rather than change their model, Meta is just not making it available, the Llama 4 models in the EU. Now it's interesting, I don't think probably this doesn't slow innovation at Meta. If anything, Zuckerberg is accelerating it as fast as he can. But I think arguably it slows innovation by our customers in the EU who don't have access to the most powerful open source model on our platform. The Apple example is another one. That's the Digital Markets Act, but they've held back AI features from their phone. I think it's interesting to think about the tech hype cycle and ask whether there's an AI regulation hype cycle following kind of the similar graph, the thing in the upper right corner. Back at the upslope, that's when, right after ChatGPT was released and everybody was surprised by how powerful, how capable AI was. But at the same time, there was a lot of concern about the potential dangers. That's when this call came out, you may remember, for a pause, 6-month pause in AI model development. There was this, the UK AI Summit, the Biden executive order, the EU AI Act was accelerating in terms of the debate. And then things calmed down a little bit, but the regulation continued to move forward. The EU AI Act was finalized last year. The Colorado Act was passed. And now we're on the downward slope, led by the Trump administration, but by other political leaders elsewhere, worried about innovation and wanting to focus less on regulation, more on innovation. And the DeepSeek jolt is an interesting one because it really shocked people in terms of the race that we might be in with China, because it made it pretty clear that China was ahead of where we thought that they were. An interesting question is, public policymakers rarely do anything big unless it's reactive, to a trauma, a jolt of some sort. And so a question might be, do we turn that bottom towards an upswing again because of some jolt, some safety risk that manifests itself? Hopefully not. Well, hopefully that isn't the cause, but I think that might be what happens. Overall, AI appears to be following the privacy path where the EU AI Act is playing the part of GDPR. And relative inactivity at the federal level is causing the states to be very active, creating this patchwork of regulation. But there are some important distinctions between AI and privacy. AI impacts the underlying technology more so than privacy regulation. And AI, because it's so powerful and can do so many different things that we don't even fully understand yet, it evokes in many people a thinking of a different array of risks and unpredictable risks. And so the regulation, as we saw on that slide looking at the frontier models, can take very many different forms. So that regulatory patchwork at the state level could be even much more disparate than it is with privacy. And the question is, does this call for, does this motivate policymakers at the national level to actually take action to put something in place that's preemptive? The main impact from Trump 2 so far has been the lack of regulation and the commitment to lack of regulation, and whether that actually will spur more regulation at the state level and therefore be counterproductive in terms of their goals of spurring innovation. What are the prospects for a federal preemptive law? I'm going to ask Alan his thoughts, but my gut tells me the logical thing would be to focus on that, the underlying technology level, and have a narrow law at the national level that focuses on frontier models, so that states like California and New York and others aren't tempted to put in place all their different types of rules. When you think about it, the technology is global, right? OpenAI and Anthropic and other Meta, they're producing models that they want to market globally. The regulation should be as global as possible, not state by state. This is a busy slide. I use it mostly to make the point that at Databricks, when we think of compliance, we're basically using the EU AI Act as our default setting. We know it's going to apply. We're global. Many of our customers are global. And then we look at things that pop up and analyze how they might go beyond the EU AI Act. And if they don't go beyond, we don't worry about it too much. And if they do, then we incorporate it into our looking at compliance. And I'm going to stop there. There are a couple of other slides. I think you can get copies. It talks about how we have an array of features on our platform that can help you address everything from testing, pre-deployment testing, to ongoing production monitoring, auto-logging, incident reporting, and all sorts of stuff. And so we'll go to questions.